ask Ms. Hawley about your basic theory of standing? And this is a clarification question as much as it's anything. When you did your 1, 2, 3 in your opening statement, it sounded very probabilistic to me. I mean, I don't remember exactly what the 1, 2, 3 are, but, let's say it's something along the lines of, we represent a lot of doctors, and there are a lot of women out there taking Mifepristone, and some fraction of them are going to have adverse events, and some fraction of those are going to come to the emergency room, and so there's some probability or likelihood that one of our doctors who has a conscience objection is going to come face to face with one of these women who has an adverse event. Is that your theory?
No, Your Honor. What we think really shows that respondents have standing here is FDA's own acknowledgments. I would point you to JA 384. And in regulating Mifepristone, FDA has continually said that emergency room doctors and OBGYN hospitalists are critical to the safe use of drugs.
Well, I think then it is your theory. I mean, you're just saying even FDA admits that there are going to be some adverse events, people are going to show up in emergency rooms, people are going to come face to face with one of our doctors who objects to some aspect of the treatment. That's the theory, yes?
Well, we certainly think all of that is true, but we don't think it's a problem with probabilistic standing, as was the case under Summers, for 3 reasons. First, Summers involved unidentified members. Here we have 7 named plaintiffs. In addition, and no one in Summers, at least that was still part of the case.
Yeah, so does your theory really depend on your having at least one person? Because I take Summers to be saying, these probability theories, they sound very nice. They have nothing to do with our Article 3 requirements. You need a person. You need a person to be able to come in and meet the court's regular standing requirements. So you agree with that, yes?
I think that's correct, Your Honor, yes.
Okay, so who's your person? I know you have 7 of them, but if you had to pick one and say, go read that declaration, and that declaration is going to tell you why we're entitled to be up here. Who's the person?
So I have to pick 2, Your Honor, but Dr. Francis and Dr. Scott.
Okay, and what about those 2 doctors gives you the kind of imminent injury, let alone the traceability, that we've typically required?
So to speak to Dr. Francis at the beginning, there's been some confusion, I think, about the precise nature of the conscience harm. But if you look at JA 155, paragraph 15, she talks about her and other APLOG members who object not only to taking the life of an unborn child during an elective abortion, but also to, quote, completing that process. That echoes the CMDA declaration at 142 and 143. It's also consistent with...
Has she ever been, because I read that declaration pretty carefully. What actual emergency treatment has she participated in that she objects to and that she has stated an objection to?
So the prior page, Your Honor, JA 154, talks about a DNC, which she was required to perform due to a life-threatening emergency.
She herself performed that?
That is correct, Your
And
Honor.
did she have an opportunity to object? Did she object?
No, Your Honor. Again, these are life-threatening situations in which the choice for a doctor is either to scrub out and try to find someone else or to treat the woman who's hemorrhaging on the
Usually, conscience
table.
objections, the way people with conscience objections do this is they make those objections known. And, that may be harder, it may be easier in a particular context, but most hospitals have mechanisms in place, routines in place, to ensure that doctors who are allowed to do this, in advance, right, and are allowed to do it at the moment, they say so. And when I looked at Dr. Francis's and Dr. Scott's, there's just nothing that you have there that suggests, this is like there are, other requirements that you need, but at the very least to be able to say, well, this happened to them in the past, I don't think you have it for either one of those doctors.
So I think we do, Your Honor. Given the emergency nature, it's simply impracticable to have a objection lodged prior to understanding what's going on in that operating room. And again, I'd point, Your Honor, to the District Court Fifth Circuit brief in EMTALA, where the government says that neither the church nor any of the other sponsors of those federal conscience protections intended them to apply in emergency situations. So it's a lot to ask our respondent doctors to go up to the top floor and litigate this with the general counsel when the federal government's telling them they don't have a conscience protection.
Is it